Supplementary list, item number 1 for pronouncement of judgment.
Who's for the
Mr. Hazarika, Lordship.
I'll just read the operative portion.
Absolutely.
In view of the above findings and observations, this court is convinced that the accused Wellen has not been able to demolish the case of the prosecution or the findings of the learned trial court in the impugned judgment, and accordingly the appeal is found lacking in substance. The same is hereby dismissed.
Obliged.
My please, Your Lordship. My Lord, I would like to make a mention for adjournment, my Lord. On a joint request, my Lord. Item number 6 and 7.
Yes, ma'am.
No objection, Your Lordship.
My Lord, this is a joint request. So Mr. Philemon Nongri has requested me to make a mention since he is before the other court, he's engaged in the other court. This matter is still pending before the Supreme Court, my Lord. This is that enforcement officer, my Lord.
Okay.
Transport officer.
On joint prayer made by the parties, matter is adjourned. This is here after 4 weeks.
My Lord, I'm highly obliged.
May it please, Your Lordship. Lordship, if I'm allowed to mention item number 9.
Yes.
9. Lordship, I'm the appellant in this matter. Lordship, slight difficulty today. This matter could kindly be taken after 10 days or 2 weeks, my Lord.
So there's an interim order operating in their favor, Lordship. So a week's time, Lordship,
Remain.
after a week.
What is there? The land will be there. It does not go anywhere.
Short date may be given, Lordship.
On prayer made by the learned counsel for the appellant, the same not be objected to by respondent. This is matter of 2 weeks.
Obliged.
Obliged.
May it please, Your Lordship. My Lord, I am back to make a mention of item number 3, hearing list. The conducting counsel is out of station, Your Lordship. On behalf of the respondent, sole respondent.
2019 matter,
My Lord,
and it's a revision at that.
Your Lordship.
Is the main case still, proceeding?
No, my Lord.
The revision has come, against a
Judgment
final
of
order
Final order of the judge, district council court.
or justice council court.
My Lord.
Who's the degree holder?
I am the degree holder.
You are the degree holder. So no execution.
They are against the interim order, my Lord.
Interim order. What is the interim order?
That has been made absolute, my Lord, entitled civil appeal. Against the injunction order, they filed an appeal. That was in our favor.
Okay, so it's not yet a final, judgment of the, the case being concluded as such. It's only at the stage of
It has been passed in title suit in the main suit, my Lord.
the main suit.
My Lord.
That would be on the application for under Order 39, Route 1 and 2.
This is the main suit. It's the final. There is certain finality, my Lord.
That's what I was asking.
My apologies. It is the final.
If in the main suit, the matter has been finally heard,
Your Lordship.
what remains is execution of the decree.
My Lord.
But why now you're saying an interim order? What is the interim order?
My apologies, my Lord.
Okay. No execution yet.
No, Your Lordship.
Is there any stay on execution?
No, Your Lordship. There's no stay, Lordship.
No, my Lord. No stay, my Lord.
Involves a landed property.
Landed property.
If I'm
Common part,
yes.
Lordship.
Anyway, on prayer made by the respondent seeking adjournment on grounds of personal difficulty of the learned conducting counsel, is not be objected to by the petitioner, whereas adjourned list the matter up to 3 weeks.
Highly obliged, Your Lordship.
Lordship, I'd like to make a mention for item 5, Lordship. Lordship, I'm praying that matter is after 2 weeks.
Is that subsidy matter?
Subsidy matter, Lordship.
Pre-made with petitioner, this is matter up to 4 weeks.
Highly obliged, Lordship.
Nothing is there.
Lordship, I'd like to mention item number 4. Lordship, this similar matter is still pending before the division bench.
Lordship, I'm for respondent number 5.
Yes, Mr. Oh, that matter is not yet.
Not yet resolved, Lordship.
Land counsel for the petitioner has submitted that a similar matter is pending before the division bench of this court, before our division bench of this court, the outcome of which will have a bearing on this instant petition. It is therefore appropriate that some more time may be allowed for the it is appropriate that this matter may be adjourned for the time being. Then counsel for the respondent has also concurred with the said submission. On pre-made, this is matter to 4 weeks.
Obliged, Lordship.
From supplementary list, item number 2.
May please, Your Lordship. Lordship, in this matter, steps had been taken against all respondents. Notices were served. And my lord, 3 days back, we have also filed our affidavit of service for all 3 respondents, my lord. If Mr. Nath is appearing for one of the respondents.
Yes, Mr. You are appearing.
We have received the copies of the appeal petition.
Are you appearing for whom?
I am for the victim, my lord. Number 1.
Respondent number 1. Who's 2 and 3?
2 and 3, owner and driver.
Owner and driver. Are they represented?
They have till now not here. They have not represented in the
Matter has proceeded ex parte against them?
Long back, in 2017. 2017 in the tribunal. And notice from this honorable court has been served. We have filed an affidavit of service also.
So 170 has been resorted to? Section 170? Is it 170 or 173?
170, my lord. 170, my lords, after 2014, it's no longer required to be, because Supreme Court clarified that if the insurance company is made a party willingly by the claimant, then insurance company has all the defenses available, which would be otherwise available under 170. But if the insurance company is not made a formal party and just notice is issued, then upon failure of the owner, etc., then 170 can be invoked by insurance company. So in this case, there was no 170 invoked for the reason that it was not required to be invoked. We were made a party originally, my lord, by the claimant.
So it's immaterial whether the owner and driver is
in fact
present or not.
Yes, in fact, a very interesting judgment that was 2014 judgment, United India versus Sheila Dutt. What Supreme Court clarified, it went into the entire act and clarified that a couple of things. Number one, insurance company is not a necessary party in MST claim proceedings. So not being a necessary party, the only obligation on the tribunal is to send a notice informing them that there is a proceeding ongoing, so that insurance company is prepared to face the liability as and when the liability may arise in terms of money, in terms of the compensation. Number two, Supreme Court also clarified, my lord, that in case you make the insurance company a party in the claim petition, then all defenses are available. So in a way, my lord, 170 has been rendered a slightly, should I say, a dead letter.
Would have been redundant by then.
Dead letter. But 170 will apply, my lord, if insurance company has not been made a party, and insurance company observing the conduct of the matter sees that there is a failure on the part of the owner to properly contest the matter, then insurance company can come in, file a 170 petition and take permission of the court to take over the defense of the owner, my lord. So this clarification was in 2014. So thereafter, my lord, in most cases, 170 is not really invoked, because the insurance company invariably, 100% of the cases, they are made parties. No one wants to take that risk.
So
my lord,
the situation means whether the owner and driver appears or not makes no difference.
Makes no difference. And also, my lord, if Lordship recalls, in one of the earlier appeals before my lord, MSc appeals, Lordship had taken the view that appeal is a continuation of the suit, of the trial, my lord. In the suit itself, in 2017 in this case, matter had gone ex parte against owner and driver, number 2 and 3. That being the case, if this appeal is a continuation of the suit, why should the owner and driver be given a second opportunity to appear when they have already chosen not to appear in the same continuing proceedings, my lord? That view was taken in one of the earlier cases. That view can be taken here also, and in any event, they've received notice. So
that view was taken then. It may not be relevant now.
It was last year, my lord, not too long.
No, it has not been challenged. So
no,
it has not been challenged.
For all we know, you see, the position put forth by this court may be wrong.
I would submit it's a very sound position based on 1953 Supreme Court judgment, my lord. Once you peruse the judgment, and this was Election Commissioner versus Sangram Singh, 1953. Lordship perused the judgment, yes. Lordship perused the judgment and came to the conclusion that yes, it is not necessary to repeatedly keep issuing notices to them.
Provisions of General Clauses Act would come.
No, General Clauses Act was not looked at or invoked or anything. It was based on that Supreme Court judgment of 1953. Lordship took, I would say, a very correct view that it's not necessary if the matter has already gone ex parte against them, if they chose at one point in the proceedings not to contest.
That is the logical view.
Yes,
but legally,
based on 1953 Supreme Court matter.
Anyway, that's beside the point.
Yes.
My lord, that there is a delay in filing this. Delay.
No, small delay of 28 days.
That application I have not received, my lord. Only I talk with you.
Oh, the main appeal has not been
Not yet.
registered.
Not yet.
Heard Mr. S. Tindal, learned counsel for the applicant. Applicant or petitioner?
Petition.
Petitioner who has submitted that the notice issued upon the respondent number 2 and 3 have been affected and an affidavit of service in this regard has been filed for this court indicating the receipt of such notice by the said respondent. However, none has appeared on behalf of such respondent till date. As far as respondent number 1, you are number 1.
Yes.
Concerned, Mr. H. Arnath, learned counsel, has entered appearance. And has chosen to contest this matter. Accordingly, the notice on respondent 2 and 3 is deemed to have been served. Next, Mr. S. Jindal has also submitted that this is an application for condonation of delay of 58 days in filing the
28.
Here is written 58.
Apologize.
Is it 28 or 58?
28.
Look at your, and this is also by hand. Must have been subsequently corrected.
Registry might have corrected by itself.
Not registry.
Because
registry will not do such things.
My copy is 28.
Why would the registry?
True. There is a correction. I'm not sure who. We have not.
What is the correct number date?
If I can explain, the order was passed on 25th April 2024. So 25th April 2024, we obtained the copy of the order, my lord, on 8th May. So limitation 90 days should start from 8th May. 8th May means May, June, July, August. 8th August approximately the appeal should have been filed. Appeal, my lord, was filed on 20th September. So from 8th August.
Oh, that is how you calculate it.
Yes, from 8th August to 20th September.
You make a correction there by hand and initial it.
Okay. I'll make it 28, my lord.
You can make it 128. You can make it. Mr. Nar will not object in any case.
I'm sure you won't. I'm sure you won't.
So already delayed for last 10 years with this case.
You'll get your interest.
My lord, that is already ordered, my lord. You heard it. My lord, we'll file our power also in the.
You have not filed your power?
No, it's with us.
Kumum tomorrow? The delay having been sufficiently explained in this petition, it is prayed that the same may be allowed, that this petition may be allowed, and the main appeal be directed to be registered. Mr. H. Arnath, learned counsel for the respondent 1 has no objection to the prayer made. on consideration of the submission made by the parties, this court is also convinced that there are good grounds for preferring the appeal, good ground for explanation of the delay in preferring the appeal. Accordingly, prayers allowed, petition is disposed of.
Well, I have a small submission. As per the provision of 173, when appeal is been filed,
Yes, that
amount of deposit
25%.
25% or 50,
25,000 or 50%, whichever is less. So we've deposited 25,000.
Yeah.
Yes.
So they have deposited. The main petition, the registry is directed to direct this appeal and list the same for admission on 3. On 30th. On 30th, matter will come up for admission.
highly obliged.
Item number 2.
Yes.
My lord, I have filed my affidavit of service, my lord, where it indicates that the respondent number 2, the notice issued upon respondent number 2 is duly effected, my lord.
Yes.
Your Lordship, as per the last order dated 6/9/2024, learned AG had submitted that there's a writ appeal pending in division bench. So, as per my knowledge, it has not been disposed of yet. So, Your Lordship may kindly grant us some time, as it has not been disposed. And he had also stated that the issues is present in that writ appeal that is pending before division bench is similar to the issues that is in this case, Your Lordship.
This is with regard to the
Check gate matter, Your
check
Lordship.
date. Yes, the counsel for the petitioner has submitted that this court, by order dated 6/9/2024, has observed, has noted the submission of the learned AG, wherein it was stated that an appeal of similar nature is pending before a division bench of this court. The decision thereof would have a bearing on the merits of this case. Accordingly, it would be prudent for this matter to be put on hold till the related appeal is disposed of. Accordingly, on prayer made, this matter is adjourned. Matter is adjourned. This is the same after 4 weeks.
Much obliged.